Good evening and welcome. I think I was probably just talking and was muted at the time, so apologies for that. Welcome, my name is Paul Lakin. I'll start again in case anyone did hear me before. This is part of our King's Chamber's ongoing series of seminars, which we are trying to, with greater success than not, do every fortnight. Today, I'm going to spend some time just looking at the case of Face and Cunningham. This is one of my cases that I did recently. Was a 10-day trial in Liverpool in the High Court before His Honour Judge Hodge QC. It raises it's an interesting case factually, and raises one interesting point legally, which does have some, although on the face of it, it appears like it's a slightly dry academic point as to the burden of proof. It can have practical consequences, which are worth thinking about in advance of any trial that you're going to be preparing for. It's also notable because the first day of the trial was the 13th of October, which, if anyone can remember, in Liverpool was actually the day that Liverpool went into tier 3 restrictions as having the highest infection rate, COVID rate in the country. So we were in the eye of the storm, starting a 10-day in-person trial. And so it's a credit, I think, to everyone concerned that it went ahead without a hitch. In terms of how it did proceed, the main protagonist witnesses were all in person. That's basically the claimant, the two defendants, and the witnesses to the will. They gave evidence in person. Everyone else gave evidence via video link, and it all worked remarkably well, with the odd technical hitch as you would expect. So, in terms of the case, the claim itself was a straightforward claim. It was the claimant was just seeking to pronounce for a copy will that was dated the 7th of September 2017 in solemn form. In other words, the court to pronounce that this was the last will and testament of Donald Charles Face and should be admitted to probate. It was defended essentially on 3 distinct bases. Firstly, that the will was a fraud. It wasn't a product of the deceased, but was produced at some point after the death of Mr. Face, and produced by the claimant in conspiracy with the 2 attesting witnesses. So it was a very serious allegation to allege in a defence. The second limb was that it hadn't been signed in accordance with Section 9 of the Wills Act. And the third limb was that because what they were seeking to pronounce was a copy will, the original will had never been located, then we were running an argument that that was a presumed destruction because the original had never been found. So even if it had been found to be valid, we were saying the testator's intention was clearly that the will was revoked. The title for this talk, The Case of the Missing Will, comes directly from the judgment of His Honour Judge Hodge, who started his judgment with the following line: if the late Sir Arthur Conan Doyle or his worthy modern day successor, Mr. Anthony Horowitz, were to write up the events which have led to this present unhappy litigation, they would no doubt have titled the resulting chronicle The Case of the Missing Original Will. So that was the judge's first sentence of his judgment. Let's just deal with the salient facts. The judgment is, as I say, it's it's reported, and you'll find it at 2020 EWHC 3119 Chancery, so you can find a full copy of it if you want to read it in its entirety. It is been a judgment of His Honour Judge Hodge. As anyone who is aware of that particular judge will know, it is quite a lengthy judgment, and the facts of this case are quite complicated in many parts, so I've tried to strip it back to give the flavour of it, but all the subtle nuances of it may be lost slightly in translation, so I apologise for that. But if you are interested, I suggest for a full recap of everything that went on and all the evidence, then the judgment is the place to go. So Donald Face died on the 2nd of October 2017, leaving an estate about £750,000, comprising of a property in Norfolk where he resided that was called True Blue, and a property in London which was 120 Maryland Road, which the second defendant lived in, Richard Caithner. So there's 2 properties and there's a number of other assets. The claimant is Rebecca Face, is the youngest daughter of Mr. Face. My client, the first defendant, Rowena Cunningham, is her sister and brother to the second defendant. The second defendant is the oldest of the 3 children. At first, when Mr. Face died, no will could be located, but then the claimant's case, as she advanced it at the trial, was that this copy will had been discovered on the 10th of August 2018 at True Blue on one of the visits. Just at that point, it's worth saying, because it's a point that's referred to in a number of times in the judgment, is this was an exceedingly dysfunctional family. Mr. Face and his wife had split up when their children were very young. Richard, the second defendant, had gone and lived with his father, so he had a much closer relationship with Mr. Face than the claimant and the first defendant. The claimant and the first defendant had gone and lived with their mother, and they had a very patchy relationship. They had no relationship at all till they were at least 18, and then patchy in terms of relationship thereafter. But a copy will was discovered, and in that will, it left everything to the claimant, essentially, and nothing to either the second defendant or the first. Sorry, the second defendant or the first defendant. The copy will professed to be witnessed by a Mr. Humphreys and a Miss McKenna. And there were witness statements from them, and their story, which I'll explain at slightly greater detail later, was that they had met the testator, Mr. Face, in a wills shop called the Inheritance Shop in Cambridge, because they had happened to go there for the day to pick up a leaflet, bumped into this old man who was carrying had a will, and simply executed it, and then they left. And that was how they say that they came to execute the will. So the will on the face of it was a homemade will, which had been typed. It was slightly odd, or the language, which I'll come to when I look at what the judge found, in that it was dated. The date had been typed in on the same day that it had been executed, because the date had also been handwritten in manuscript, which was the 7th of September, which meant the document itself had been typed, or at least typed, finished and printed the day it was purported to have been executed. It couldn't have happened any other day. I suppose in theory it could have been done in advance with that date, but then that ties you precisely to that day that you've got to go and get it executed, which again, to a lawyer would strike you as slightly odd. So to that extent, the facts are rather straightforward. The main battleground between the parties was whether this was a genuine will or a genuine copy of a will, or whether or not it was, as both defendants put forward, a forgery created by the claimant in a brazen attempt simply to fraudulently obtain the entire estate for herself. Which raises the one, and I'll deal with the one legal point first, which is about proving on whom does the burden of proof lie when you're dealing with a forged will. Now, just to go back to basics, the person who is seeking to propound a will bears the ultimate burden that the will is valid, because that's what you are, that's the whole point of proving a will in solemn form. That's what you are at court for. So they have to establish basically that it is formally valid, in other words, that it complies with the Wills Act and it has been witnessed and executed according to the terms of statute, and that it is substantially valid, in other words, that the testator had testamentary capacity, knowledge and approval, and it wasn't procured by fraud or by undue influence. Again, there's nothing unusual about that. And to assist any would-be person who is put in a position where they have to prove a will, often, well, clearly the testator, you know, the person who's made the will or whose instructions have been given to produce the will is dead. That's the nature of it. And frequently, the witnesses either can't be found or located or have also died, because it can be many years when it comes to being proved. So in order to assist, there are two main presumptions that the court will rely upon in the absence of anything else, which is, and the first one is there, where the face is regular, on the face of it, it's apparently executed, there's an attestation clause and it looks like it's been complied, then the court will assume that statute has been complied with. So it is formally valid in that sense. Likewise, if you can establish testamentary capacity, and in our case, no one was trying to say that Mr. Face wouldn't have had capacity at the material time, even though it was only a month before he died, and there's due execution, then knowledge and approval are assumed. So those two presumptions assist anyone who's seeking to propound for a will in solemn form. Now, the burden of proving fraud, and again, this isn't really anything controversial, and it's the same in most areas of the law. If you are alleging something, especially fraud, which is, again, is particularly serious, the burden is usually on you as the party alleging the fraud to prove that fraud. In fact, all the leading textbooks, which is Theobald on wills, I think Judge Hodge also refers to Williams, Mortimer and Sunnock's, which says basically the same point, that the legal burden of proof of undue influence or fraud lies on the person alleging it. That person must prove that the will or such part as he alleged to be invalid was made as a result of the undue influence or fraud of another person. So you would think, given clear citing of that authority, and the authority that most of the textbooks rely upon is the Hyder and Said case, which is the decision of Mr. Justice Barling. Although it's fair to say it is based on an acceptance by counsel, because the relevant part of the judgment is what's typed there, which says Mr. Charles Machin of counsel, who appeared for the defendant, accepted that given the serious nature of allegation of forgery, the legal burden of proving that the signature on the will was forged rested on the defendant. He also accepted that cogent proof is required from the party making an allegation of forgery, albeit that the civil standard, viz. The balance of probabilities, still applies. So again, entirely consistent that the burden is on, or would have been on us as defendants, to establish that this was a forged will. What His Honour Judge Hodge found is this, which is, again, slightly unexpected. He said, I do not accept that the burden is on a person alleging forgery to establish that fact a bit to the civil rather than criminal standard of proof. It is a formal requirement of the validity of a will that, amongst other things, it is in writing, it is signed by the testator or some other person in his presence and by his direction, and is duly witnessed. It therefore seems to me that the burden must rest on the party propounding a will to establish that it has been validly executed and witnessed. That is one of the formal requirements for proof of a will. I can well understand that a will, where a will is challenged on the grounds of fraud or undue influence, the burden is on the party asserting that. But where the forgery of a will is alleged, then the ultimate burden of proving that the will is not a forgery must rest on the party propounding the will, as part of the formal requirements for proving that the will was duly executed by the testator and duly witnessed. It seems to me that Hyder and Said is no authority for the proposition that the burden of proof rests on a party alleging that a will is forged because the position was in no way challenged in argument in that case. So I accept what the judge says in terms of it wasn't challenged in that case, but all the leading authorities seem to suggest that that's not the proposition that the judge has put forward. It is, and there is a slight lacuna here, simply because it must follow that if a will is forged, A, it doesn't comply with Section 9 of the Wills Act in that it doesn't bear, that's not the signature of the testator, and it wasn't witnessed, it's not the act of the testator. And secondly, there can be no substantial validity because clearly there's no knowledge and approval because he knew nothing about it. It's not his act. So how do we tie up what the judge has said here, that the burden is actually on the person propounding, what the authorities say and what the textbooks say? But I think there is a way of dealing with the two. And this is a point that was raised in Gilham Woodhull by Lord Newburger in that case, because what he said in judgment was that approach seems to me to be consistent with what was said by Lord Justice Linley in Tyrrell and Paynton after referring to Barry and Butlin, where Park B discussed circumstances ought generally to excite the suspicion of the court. Lord Justice Linley went on to say, wherever such circumstances exist, and whatever their nature may be, it is for those who propound the will to remove such suspicion and to approve affirmatively that the testator knew and approved of the contents of the document. And it is where this is done that the onus is thrown on those who oppose the will to prove fraud or undue influence or whatever else they rely on to displace the case made for proving the will. So I think my view is the proposition is the burden is and remains always on the person seeking to propound the will to prove that it's valid. If the court, and here that to what degree is another question which I'm not sure has been answered yet, but if the court has suspicions, in other words, there is sufficient evidence, I would say, to question whether or not they can rely upon the simple presumptions that I talked about before, then they have to basically present evidence in order to establish that those suspicions aren't real, you know, that they've been removed. And it's only if they establish and get over that evidential hurdle that then it falls upon those who are alleging fraud, that ultimately they would have to establish it at that point. So I think that's what the actual correct answer is. Although, as Judge Hodge makes clear in the decision, because of the findings of fact that he made, there's not many cases where the actual burden would make a real difference on who it fell, save for, and this is the important bit, and this was something that was actually canvassed at length at the PTR, which is who are calling the attesting witnesses. Up until this point, the claimant had produced witness statements from each of the attesting witnesses. Clearly, we wanted, as first defendant, to make sure that they attended. And my instructing solicitor had procured witness summons for both witnesses so that they were compelled to attend. But it was still possible that the claimant wouldn't have called them as witnesses. There's no property in a witness. They could have just, she could have said, I'm quite content to rely on the presumptions of due execution. We've got their statements. I'll rely on that as hearsay evidence, even though I've not served the Civil Notice Act, but I'm not calling them. In which case, that would fall on us to call them as our witnesses. Now, at first, you think, well, that's all right, save for the problem that creates in terms of cross-examination. Under the CPR, witness statements stand as evidence in chief. You can only ask if you call the witness further questions to give an explanation to certain parts or to bring a witness statement up to date. What you're not allowed to do is cross-examine your own witness. That would cause, or potentially cause, a real problem if you call the very people that you don't believe that their account is in any way true. There is still a mechanism. I mean, it's very rarely used. There is a mechanism by which you can ask the court to treat the witness as hostile and cross-examine accordingly, but that puts you at a slightly disadvantageous position because of the whim of the court can refuse or not refuse that application. And then you're bound by the terms of the statute, which you've got to refer to. What you want as defendant in these circumstances, you want the claimant to call them. And if it is, as Judge Hodge found, or as I am saying that the law really stands, then it falls on, as long as it's accepted that there are suspicions that raise sufficient questions so that the claimant has to prove the removal of those suspicions, then it clearly falls on the claimant to call those witnesses, those attesting witnesses. So that's the upshot, that's the practical thing, and you want to make sure that you are prepared for that, whichever way it goes, and know, ideally, as I say, you want to make sure that the claimant does it so that you can cross-examine accordingly and put precisely your case. And the other thing as well, just as of course a matter of practicality, is you want to make sure that your witnesses are not in the same room when one is being cross-examined. We had them excluded so that they couldn't hear what the other was saying, because clearly you don't want one to sit there, hear what the first one says, and then just regurgitate it. So that's the legal point that was at the heart of it. Now, what did the judge find? The judge found, and this is a quote from it, he said, I am led inextricably to the conclusion by the following four particular features of this case, which, considered separately, are highly suspicious, and which, when taken together, in my judgment, clearly demonstrate that this will is a total fabrication. And these four matters are the very existence of any will at all, 2, the terms of the 2017 will, 3, the circumstances surrounding the alleged execution of the 2017 will, and 4, the circumstances surrounding the alleged discovery of the 2017 will. Just pausing there before I just talk about each of those aspects. It is common, and this is to some extent is true of all cases when you're building a defence or even a claim. There's very rarely is there the one knockout piece of evidence that demonstrates one way or another. The whole case, the whole defence is built up as you would almost a wall, brick by brick, of putting in individual bits that you hope, when it's built, will build a picture that leads the judge to one conclusion and one conclusion only. I should say there was before the court a handwriting expert, but anybody who's dealt with handwriting experts can guess what their conclusion was. Their conclusion was they couldn't be conclusive either way, whether it was a forgery, whether it had been added or anything. So that report was really of no assistance to the court whatsoever. So dealing with each of those parts, the very existence of the will at all, this was helped by the fact, again, fairly rarely, that Mr. Face kept a journal. He kept effectively a diary every day of events that occurred through his life and had done all his life. What was unusual is that whilst the court had a number of older journal years, it had the 2016 full journal, but for 2017, the relevant year, it didn't have that journal. All it had is certain extracts of that journal. There was a dispute between the parties as to who actually had that document and who was suppressing it. The defendants both said the claimant had it. The claimant said it was the second defendant and that she had discovered these extracts in a carrier bag behind her car and she didn't have the entire document. And so you can imagine that the extracts that were provided to the court didn't, surprise, surprise, relate to any of the material days, like the 7th of September wasn't there, or when any particular conversation was supposed to have happened that may have assisted the court. All those were written. But what they did provide, and what was exceedingly useful, is they provided a picture, like any diary does, of the man himself in a way that it's very difficult to get that kind of evidence, usually before the court. So he could see what he wanted to do and what he wanted to achieve. And there was no documentary evidence at all of an existence of a will. That was further compounded by the fact that my instructing solicitor was Mr. Face's solicitor at the time, and his evidence was he'd been trying to get him to write a will from mid-20, or certainly August 2016, but he just hadn't. And that Mr. Face had never at any point told him that he'd made a handmade will and had it executed. Compounded with that is that my client, the first defendant, gave evidence that she'd had a conversation, which the judge found was on the 26th of December as a fact, in which he'd specifically said he hadn't made a will. So all of those facts taken together meant that it was inherently unlikely that a will existed at all. And the fact, again, that upon his death, no one could find it. These are three fairly warring siblings, and the locks, I think, were changed on the house at least half a dozen times as people basically claimed title to it and title to the possessions inside it, and mainly the second defendant and the claimant were fighting between them as to what was theirs and not. So the house had been ransacked and yet no one had managed to locate any will. So those are all the facts that pointed to the fact that this will existed at all was dubious, to say the least. Then the second point, which was the terms of the will. Now, the terms of the will were particularly interesting. I've already mentioned the fact that it bore the specific date, again, which is very unusual. Let me just try and find, sorry. But in terms of what it actually said, no, it said, it basically said, I give my whole estate to my daughter Rebecca, Face. And then it said, I do not give anything to my son, Richard Caithner. But then it went on and gave a sort of a narrative as to why in the will it was said those reasons why the testator was making those decisions. It says, you don't talk to me, you don't answer to me. And specifically it said, you do not tell me you were married, you did not tell me of your child, and I do not know why. Now, it transpired, and the evidence came out at court, that Richard Caithner did have a son, but his father never knew about it. And as coincidences would happen, his wife and child came into this country on the 7th of September 2017, the very day the will was executed. And so his father simply could never have known and never have put that clause in about Richard of having had a son. At one point, this led the claimant to advance the notion that her father must have found out because various people were looking out of the windows, notified him. He'd gone down to London, tried to see him, hadn't, was so upset that he'd then come back, written this will, gone off to Cambridge, had it executed, and it was just became this long, improbable tale of things that just simply clearly never happened. So there was the terms of the will. And the other thing is when it was talking about not leaving anything to my client, Rowena Cunningham, it used her married name. In all of Mr. Face's journals, and he even left some notes as to who to contact on his death, he used her maiden name, Face. He never used, there wasn't one document when he'd referred to his daughter Rowena where he'd used her surname. So again, the fact that it uses her surname, and there was evidence to suggest that he didn't even know what her married name was. So that, again, and also the fact that, oh, excuse me, the picture of Mr. Face given in terms of evidence and how he was as a man was simply not that he would have written a will in this terms, which was quite, I think my instructing solicitor in his evidence said it was, you know, it was a vile will, it was a vengeful will, and this wasn't a picture of the man. So again, the terms of the will were dismissed as being that of Mr. Face. So in terms of the fourth one, the allegations of execution. Now, the evidence of the witnesses, as I say, they lived in about 20 minutes away from the outside of Cambridge. Their story was that they wanted to write their own wills and wanted to pick up a leaflet from the inheritance shop where they knew where it was on the outskirts of Cambridge. They set off to pick up a leaflet, went in, saw this old man waving a will, who asked them if they would mind executing it. They read it, executed it, got a leaflet and walked out. And that was their simple case. The only problem was, well, when they were cross-examined, their story just simply didn't really hang together in any way at all. there was no need for them to have made a will or even want to make a will. They were in rented accommodation, they had no assets. They say they wanted a leaflet and obtained a leaflet that was required to give details about how to make a will. Whereas the evidence we had, the owner of the inheritance shop said no, all he had is leaflets that talked about the services that were offered. And in any event, they were in a dispenser outside the shop. So they didn't, if they just went for a leaflet, they had no need to go into the shop at all. And also he gave evidence that there was always be someone manned and they wouldn't let anybody else execute a will on their premises. And their cross-examination, they could give the details that they had referred to in their witness statement, but they were unable to give any details of anything at all. They clearly hadn't thought about it. And it was the classic example that they'd learned and understood what they were supposed to say, but asked them about anything else, because there was evidence that Mr. Face wore a hat at all times, even indoors. They couldn't give any description of him. They certainly wouldn't mention the fact that he probably would have had a hat on. And so their evidence came across as simply unbelievable, which is ultimately what the judge found. But also, what would have perhaps proved quite a difficult hurdle is, why would two people put literally almost their necks on the block to come to court to perjure themselves for two people in theory they had never met? Well, this is where my client and my instructing solicitor managed to do some digging just before the trial. And it transpired that the claimant was in the army. She was an armourer, and that's where she met her partner. Her partner was in the Royal Mechanical Engineers. And it just so happens that Mr. Humphreys, who was one of the testamentary witnesses, was also in the army, in the Royal Mechanical Engineers, at the same time as the claimant and her partner, and also at the same time as they were in Germany, just in different bases a few miles apart. And my client managed to contact someone else who was in the army, who managed to do a bit of digging in Facebook, and it transpired that just a month before this will appeared, that the claimant's partner was trying to locate Mr. Humphreys. Now, that was, of course, all denied by Mr. Humphreys and all denied by the claimant's partner. But again, a remarkable coincidence. They, of all the people of all the gin joints in all the country, they happened to be the one that executed the will. So perhaps not surprisingly, the judge rejected entirely their evidence. Likewise, the evidence surrounding how the will was supposed to be discovered. What was put forward is that it had been discovered when the claimant had gone round the property in August the following year. The second defendant was all at the property, and there was a row, and the police were called, and the police were present, and the second defendant was kept outside. She popped in for no longer than 5 or 10 minutes and discovered this folder that was under a sleeping bag. Now, I should also mention that it's dark at this point, and she was using a torch because there'd been a burst pipe, so the electricity wasn't safe because it had got waterlogged. So there's no electricity on in the house. So she's going around the house to inspect it by torchlight. She sees, on her case, a red folder and happens to notice by torchlight on a quick flick that the very document at the back of this folder was a copy of the missing will. Now, given that the second defendant, her brother, is outside, she doesn't go and show the will or even the folder to her brother. What she says she did is shove the file down the back of her trousers, cover it up with a jacket and walk out. And again, and she doesn't also show it to the police, which you would have thought might have been a sensible thing to do. Again, we had evidence from independent sources that she didn't have a jacket on. So that, again, was wholly unlikely. And it was wholly unlikely that she would discover this file in the dark in the very limited time that she had. But the matters didn't end there, because having found a will, what her and her partner say they decided to do, Mr. Face lived about 40 minutes from Cambridge, and the witnesses another 20 minutes the other side, so about an hour's drive away, and this is about 9 o'clock at night. They drove to the address given for the witnesses. Again, why you would do that, I don't know. And said, hello, did you witness this will? And apparently they said yes. And they had a cup of tea and went home. Again, the judge rejected entirely that evidence as being wholly unlikely. So what he found was this, that the will, see, for the he set out there, for the reasons I have given, I dismiss the claim by Rebecca as totally without merit. My order dismissing the claim should include my recording that the claim is totally without merit. It is based on a fabricated document, and I pronounce against the alleged 2017 will. I declare that Mr. Face died intestate. So he rejects entirely the notion that the 2017 copy will was the last will and testament of Mr. Face. But he also directed that a transcript of the judgment be obtained at public expense and be sent to the official receiver in Croydon. The official receiver, there's a property aspect to this claim as well, but I haven't touched on at all. The official receiver is reference to that, but the relevant bit is that it should be sent to the Crown Prosecution Service for potential proceedings against the claimant, her partner, and the two witnesses, because potentially there is perjury, perverting the course of justice, conspiracy to defraud. There's a whole raft of potential criminal matters that could be taken up and presumably are still being pursued by the CPS. So there are a number of things. One of them is, as I say, we didn't have one single piece of evidence which we could point to and say that definitely makes this will a forgery. What it was about building pictures, building explanations, and undermining the credibility of the evidence that's been put forward in support of the will, which on the face of it could potentially be the will of Mr. Face. It's of note that, of course, the claimant ended up being a litigant in person, and that may be because she didn't like the nature of the advice that was being given. But the fact that there isn't the one obvious bit of evidence means that that's clearly why it got to trial. It wouldn't get to trial if it was clearly a forgery, or say the handwriting expert had come back and been unequivocal about things. So the point in terms of to be aware of when planning and preparing for a case like this is, firstly, you want to maneuver yourself so that you are cross-examining the witnesses that you want to cross-examine. That's important. You don't want to end up having to call them yourselves, because that potentially puts a real brake on what you can and can't do. Certainly you can't cross-examine them unless you get them declared hostile. But you also want as well is to paint a picture of the man or woman, whoever it is, who is the testator or testatrix in this case, to paint a picture for the court so they can see whether or not it's really likely that what they are doing, or what they would have done, which is usually in a forged will case, leave everything to one particular person, or at least the lion's share, whether that was really likely, whether that's actually what they would have done for whatever reason. And then, as I say, it's about building blocks to put into place. The family, as is often the case and is often the way with probate cases, was dysfunctional, was described as dysfunctional. The claimant announced halfway through the proceedings that she had autism. The judge questions in the judgment whether the second defendant, Richard, whether he also had autism, which again may go some way, although not entirely, explaining how they got to the position that they were. So as I say, hopefully that has been of some interest. If you want to go through it in all its detail, find the judgment and read that. If you have any questions, you've got all my details. That's my Twitter, name, handle, I don't know, whatever it is, when you want to tweet. There's my email address and my clerk's email address. If you've got any questions, by all means, drop me a line. One of the things at King's that we are keen on is that we are relatively friendly. I say relatively. We don't bite often, and we're more than happy to assist in any way we can. And it doesn't mean that, you know, if you give me a call and just want to have a query, you're not going to get a fee note for every 5 minutes. So by all means, get in touch. Any questions, I'll be more than happy to answer. I should, again, just express my thanks. I think David is tuning into this, to my instructing solicitor on this case, who did an outstanding job both in his evidence and in the preparation of the case. And so I'll leave it there. Keep tuned. As I say, this is our series of talks that we are going to do, and there is another one in a fortnight. So keep a weather eye out for that, and we'll see you then. Many thanks, and I hope that has been of use. I'll stop there. Thank you.